And so as we look at those challenges, which is why we often consider TPL to be part of complex claims, for most hospitals, accident accounts are not their largest sector of accounts, unless maybe you're a trauma center. And even with those, there being a smaller pool, some hospitals may ask, why does it even matter? Why carve out these accounts? Why should you not just let these go on through your usual revenue process flow and with any other payer that may be identified? There may be a small amount of your inventory. However, there's also an opportunity whenever you're specializing in these identified accounts for multiple reasons. And the first of those is with this small amount of your AR, it is often your highest paying class of accounts. On average, collections from TPL may be above 40 to 50%, of which is not typically recovered on average from any of your other health payers or any of your self-pay inventory. These are also your only available payers that may be able to pay you full charges and not just a discounted or contractual rate. And compliance. With state Medicaid and federal regulations, they usually require that if hospitals know a patient is being treated due to an accident, that those hospitals take due diligence in billing any TPL payer that's primary to Medicare and Medicaid. Because of this compliance, if it's not billed properly, you could receive a denial on those accounts, which slows down your payments and your AR, requiring additional time for your staff to rebill. And for even those self-pays, those TPL payers will pay faster when these accounts that wind up not going through the bad debt process. So by properly structuring a TPL process, more accident accounts are identified and properly billed, which decrease your denials and allow an opportunity to maximize on collections for this book of inventory, increasing your cash that otherwise could have gone unnoticed. And as Justin mentioned, looking at the different types of coverages that you run into in looking at these. When you look at accident-related accounts, there can be multiple available payers, and each one has a different impact in your timing and in your collections. So it's important to recognize the nuances and understand the difference in these different payers to be able to maximize that TPL process. MedPay and PIP, or as you may hear it recalled as personal injury protection, those are considered your first party coverages, and that usually means that those are primary and typically your first paying payers. That coverage is created to offer quick financial assistance to injured patients and help them recover their medical bills, but it can also go toward lost wages, household services for those accident victims. And this is the patient or the driver or owner's insurance, and that covers the car in which someone is riding in. So it pays regardless of if the insured was at fault or not. MedPay coverage is not required on your insurance plan and does have limited policy limits. We typically see those being much lower paying limits of $1,000 to $5,000, which means that it exhausts quickly. This is why it's vital to identify those coverages and bill those early before those benefits exhaust. Payments are also usually directed by the patient. So for most states, any available coverage, then those liens may not be applicable to those if there's a filed hospital lien. With PIP, it is first party, but it does differ slightly from your traditional MedPay coverage, as most states, such as Utah is an example of one, most states do not require it, but Utah, being a PIP state, does require mandatory PIP coverage on your insurance policy, and it is always treated as primary coverage. In addition to that first party, some patients may also have liability coverage if another party was found at fault for the accident. And this coverage is determined by fault and is required by state law to carry any of those minimum coverages to help with the medical expenses of an accident victim injured if it's due to the fault of another person. So although this coverage is usually more than your first party coverages, there still are policy limits that come into play. Typically, you have minimum limits of those of $25,000 to $50,000 is usually what we see, and those minimums are set by each state. And so, unfortunately, we also see too often that the medical costs due to accidents for many patients that have significant injuries, that typically those medical bills may be greater than those amounts of policy limit coverages available. And so for too many of those instances, we also find the at-fault driver may not have any coverage at all, even if required by law. So therefore, a patient may also have an underinsured or uninsured motorist coverage that could be available to pay, which can be added by a patient's own policy to protect them in the instances of other drivers for those situations where there's just too little coverage available or no coverage at all to help them to cover the damages that they have incurred due to an accident. When we talk about PIP, this is also maybe called no fault. So each state is either considered an at fault or a no fault state, depending on their legislature's determination of insurance law. The majority of states we see are considered at fault states, in which a determination of fault is made in each accident that occurs involving multiple parties, and that party is deemed responsible for making the other party whole. As this can often be disputed as to the fault, the measure of each particular party's fault, as well as the damages that are incurred, these matters may be litigated, and that often prolongs these settlements. That delay can be caused for many states, can be caused for many reasons, because in some states there's a statute of limitations as to when the patient's even required to file a complaint. And they usually have at least up to a year, sometimes up to 3 years, before they're even required by law to file a complaint to pursue on those damages, in which allows more time that it may take for it to be prolonged. And even when those cases, once litigation may be filed, those cases can continue to drag out as they go through the discovery process and those motions before the case is ever tried and ruled upon if there's no settlement prior. There are a few states, such as we mentioned, such as Utah, that are considered no fault or PIP states, in which the legislature looks to reduce the amount of that litigation and the timing and the discovery that is required to determine that fault, and just have each party pay their own medical expenses regardless of the fault. For no fault states, most usually have higher PIP limits to cover those injuries, and they may also require a higher standard of fault be assumed before they require that a party make amends for each of those in those situations.